Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. Today, we have gathered to discuss about a landmark judgment that is prescribed in our AOR syllabus also. But before going to touch upon the topic, it is our regular practice that we recite preamble before we begin our session. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation in our Constituent Assembly this 26th day of November 1949 do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, we strongly believe that every citizens of the country must endeavor to bring what are the goals enshrined in the preamble into real terms. So that is why we strongly believe that preamble our goal, preamble our soul, preamble our commitment, preamble our sentiment, preamble our dignity, preamble our unity. This is our lecture number 56, dear friends. The minority view by Honorable Justice Dipankar Datta and Honorable Justice Satish Chandra Sharma. So what the Honorable two judges have said? Let us go step by step, dear friends. Firstly, the conclusion that you will find at para 149 and 150. At para 149 and 150. What is the conclusion by the Honorable Justice Dipankar Datta ji? My Lord has said, I am reading 149 of the original judgment. In light of the above discussion, the claim of the appellants, that is ALIGARH Muslim University, cannot stand. ALIGARH Muslim University was neither established by any religious community. This is the finding. ALIGARH Muslim University was neither established by any religious community, nor is it administered by a religious community, which is regarded as a minority community. Hence, AMU, ALIGARH Muslim University, does not qualify as a minority institution. Protection under Article 30, Clause 1 of the Constitution is thus not available. The submission of the appellants has no historic, legal, factual, or logical basis. Why His Lordship is saying that? Dear friends, here the Honorable Justice has taken completely a different view. They have said it is neither established by any minority nor administered by any minority. Therefore, it is not a minority institution at all. According to His Lordship, in his minority view, has held that it was a creature. AMU was a creature of the statute. So when there is a statute, that means it must be obedient, it must be in consonance with the Constitution of India. Right? it must obey the constitution provisions. And here AMU falls under the category of Article 12, that is state. Once you say that it is a state, AMU is a state, within the definition of Article 12, automatically right to equality. It cannot discriminate on the basis of religion, race, sex, place of birth. That cannot be discriminated. Fairness should be there. Priority to merits should be given. So therefore, it is a state. It will fall under Article 12. And what is our preamble says? Justice, social, economic, political. Liberty of thought, expression, belief, faith and worship. Fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So therefore, you cannot discriminate on the basis of religion because it falls under the state. So therefore, it is neither established by any minority nor administered by any minority. It falls under the definition of the state. Therefore, fair play, equality, discrimination, no discrimination should be there. And it is completely funded, it is helped and funded by the central government. So once it is aided by the government, it loses its characteristics of minority. They cannot have complete control over the institution. So therefore, it is not at all a minority institution. That was the view of the Honorable Justice, my Lord Dipankar Dattaji. In terms of, next finding is, in terms of clause 5, Article 145 of the Constitution, it is my firm opinion that not only do the references not require an answer, it is also declared that AMU is not a minority educational institution and that the appeals seeking minority status for it, it should fail. So here we are not pointing out the principles, and that based on the principles it will not be decided by the regular bench, because according to his lordship, reference is itself bad. There cannot be a reference at all in this case, and it need not be decided by any regular bench at all, because his lordships in his firm opinion that it falls under the definition of the state. Reference is failed. That is what his lordship is saying. In terms of clause 5 of Article 145 of the Constitution, it is my firm opinion that not only do the references not require an answer, it is also declared, his lordships declaring that AMU is not a minority educational institution and that the appeals seeking minority status for it should fail. So this is what his lordship's view. So it is completely a different view from the majority opinion also, as well as from the minority view rendered by Honorable Justice Suryakant Ji also. Now moving on to Honorable Justice Satish Chandra Sharma. His lordship's conclusion. Here, what about the referral? According to Honorable Justice Chandra Sharma, Satish Chandra Sharma, my lord, according to his lordship, that referral was bad as far as Anjuman case is concerned. But the reference by the Chief Justice was correct. Why the referral was bad here? Because the referral by the two judges bench, quoting the numerical strength without Chief Justice of India being in that quorum, therefore it is bad. Let me read, dear friends. The bench of two judges in red petition number so and so 54 to 51 of 1981, titled Anjuman-e-Rahmaniya and others versus District Inspector of School and others, could not have referred the matter to a bench of 7 honorable judges directly without the Honorable Chief Justice of India being a part of the bench. So a Chief Justice of India not being a part of the bench, they cannot decide the quorum. Therefore, referral is bad. Now, with respect to the clarification of Anjuman is concerned, I am reading 266, dear friends. 266, para 4 and 5. The notion that Ajit Bashaw categorically prohibits minorities from establishing universities due to statutory requirements is unfounded. The bench in Ajit Bashaw and present bench are faced with the unique situations and needs to adopt a suitably modulated approach. The judgment in Ajit Bashaw does not preclude minorities from establishing universities, but rather highlights the importance of legislative intent and statutory provisions in determining an institution's character. Here, His Lordship is clarifying what is Ajit Bashaw is all about. In Ajit Bashaw Constitution Bench, they have held AMU, ALIGARH Muslim University, is not a minority institution. Why they have said so? Because as per Ajit Bashaw, the minority institution was not created or was not established and administered by Muslims. It was created by the legislature, by the statute. Therefore, it cannot come under minority institution. That was the finding. That was the ratio in Ajit Bashaw case. But His Lordship Satish Chandra Sharma ji is holding that they are not against, Ajit Bashaw is not against the minority institution, but they are highlighting what will amount to minority institution, what will not amount to minority institution. So His Lordship has clarified to that extent. The minority community may conceptualize the idea of an institution and may advocate for the same. However, if during exchange or negotiation, the actual institution which was established had primacy of governmental efforts and controls, then such institution cannot be held to be predominantly established by the efforts and actions of the minority community. His Lordship is saying that though it may be established by a minority, but during negotiations with the government, when the government play a vital role, that means we cannot say it is established by the minority. So the role of the government is major. That means it will not become a minority institution. Now coming to the administration, the use of the phrase establish and incorporate by the legislature may be relevant in the larger inquiry, but cannot be said to be conclusively determinative of the factum of establishment or not by the minority community. If the intention of the legislature is to establish or incorporate or recognize a minority institution, minority university, the legislatures have incorporated suitable provisions to color the university with the minority identity. So dear friends, so this is what the clarification given, and one crucial aspect is what is establishment and administration as per His Lordship is, that is explained in para 4. What is the real test according to His Lordship? The real positive indicia for determining the question of establishment of an institution would have to be developed on a case-to-case basis with the following broad parameters. What is that parameter? What is the term establishment? According to his lordship, firstly, to claim establishment, the minority community must actually and tangibly bring the entirety of the institution into existence. The role played by minority community must be predominant. So the role played by the minority community must be predominant. In fact, almost complete to the point of exclusion of all other forces. The indicia which may be illustrative and exhaustive in this regard may be the nature of the institution, the legal statutory basis required for establishing the institution, whether the establishment required any negotiation with outside forces, the role in acquiring lands, obtaining funds, constructing buildings, and other related matters must have been held completely by the minority community. Similarly, while teachers, curriculum, medium of instruction, etc., can be on secular lines, however, the decision making authority regarding hiring teachers, curriculum decisions, medium of instructions, admission criteria, and similar matters must be the minority community. The choice of having secular education in this institution must be made expressly by the minority community, demonstrating the link between the institution and the persons claiming to establish it. Secondly, the purpose. His lordship is concurring with the majority view, that is idea, purpose and implementation. Now coming to the purpose. Purpose of the institution must have been to predominantly serve the interest of the minority community or the sole betterment of the minority community, irrespective of the form of education provided and the mode of admission adopted. Therefore, as per the choice of minority community, an institution may have secular education, but such secular education and the resultant institution must be predominantly meant for the overall betterment of the minority community. Now moving on to the administration. Thirdly, in the institution must be predominantly administered as a minority institution with the actual functional, executive and policy administration vested with the minority. Here also the administration, the control must be by the minority. The minority community should determine the selection, removal criteria and the procedures for hiring teaching, administrative staff and other personnel. The authority to hire and fire staff must be from the minority community. Further, even if the teaching or administrative staff may include non-minority persons, the final authority exercising functional, discretional and policy control over these authorities must be from the minority community. This ensures that the thoughts, beliefs and ideas of the minority community regarding administration are implemented in reality. This represents the real decision-making authority of the institution being of minority community. So therefore, dear friends, his lordship is also agreeing with the term establishment. To test the establishment is concerned, idea should born out from the minority. Purpose must benefit of the minority, and implementation must predominantly by the minority people. What about the administration? Even the administration can be done by other community also, but final say, the final authority must lie with the minority. So these are all the principles laid down by His Lordship Satish Chandra Sharma ji. Now coming to this majority, and let me sum up now, dear friends. We all know that majority view has a binding effect. Majority view is the law of the land. But what about this minority view? Minority view is not the law of the land, but still The judges express their belief, faith, conviction. What do they feel with respect to this judgment is concerned? So, at one point of time in the future, even minority view can become a majority view. We have seen in many judgments where the majority is overruled and minority decision has become the majority in coming days. So therefore his lordships have elaborately discussed about what about the reference. Now let me sum up with respect to the majority is concerned, because that is the law of the land. Authored by Chief Justice of India Dr. D.Y. Chandrachud, my lord has said, the referral is good. The referral by Anjuman-e Rahmaniya, 2 judges bench, doubting the correctness of 5 judges in Aziz Basha, was correct. There is nothing wrong as per the majority is concerned, because a 2 judge bench can always doubt the correctness of the 5 judges bench, and they can refer the matter to the Chief Justice of India to constitute. So therefore that is correct as per the majority is concerned. Even the reference by the then Chief Justice, my Lord Ranjan Gogoi, was also correct. This is the majority view. Number 2, whether Aziz Basha, that is Constitution Bench judgment, which held that AMU is not a minority institution because it was not established and administered by minority, it was only a creature of a statute, ALIGARH Muslim University Act 1920. That is what Aziz Basha held, but that was overruled by the majority. Why it was overruled? Now the question is, why it was overruled by the majority? It was overruled by the majority because they have tested the establishment and administration. It was established by long back in 1870. It was established by minority. Idea has come from the minority Muslim community. Purpose to benefit the Muslim student. Implemented by minority. Therefore, establishment is qualified. Administration. Though administration may be from any other community, administration cannot be a precondition to test the minority institution. It is a single test. Establishment is sufficient. Administration is a consequence of the establishment. Therefore, we cannot put an administration as a precondition to the establishment. Therefore, establishment is sufficient. And what about this statute? How Aziz Basha was overruled? According to the Chief Justice of India, the majority view is already ALIGARH Muslim University was existing, but it is establishment was recognized by the statute. So in my humble opinion, this is my words, when a child is born, we need to register the name of a child under the Birth and Death Registration Act. If child's name is not registered, does it mean that child is not existing? Or if there is a dead person, a person is dead, it has to be registered. If it is not registered, does it mean that person is living? The person born is born, the person dead is dead, but it is a legal recognition under the act. So in my humble opinion, this was in the view of the majority that it is a recognition to the establishment which was already made. So ALIGARH Muslim University Act recognizes the existence of minority institution created by Muslims. Therefore, Aziz Basha was overruled by the majority. So this is with respect to the Aziz Basha correctness is concerned. Then third test was establishment and administration. Just now I have quoted establishment means it has to qualify whether idea has born out from the minority, purpose for the minority, benefit of the minority, implementation, infrastructure, fund arrangement, construction, teachers appointment. So this has to implemented by the minority. So establishment is fulfilled. And administration, according to the administration is concerned, administration cannot, one of the conditions, cannot be a condition to test whether it is a minority or not. Establishment is sufficient. Consequence of establishment, administration comes. Administration can be done by any community because they may be efficient. But that should not lose, that will not tend to lose the characteristics of minority. So establishment is sufficient, administration can be done by any person, but that administration cannot amount to affect the minority status. That is the precondition. So now we have seen the majority view with respect to the establishment and administration. Now the next question that was before the majority view was whether Article 30 protection can be extended retrospectively to the minority institution which was established in the year 1920. His lordship, the majority view was we cannot have two separate classification, pre-constitution or post-constitution. They are asking a very beautiful question, dear friends. What is that question? When it was established in the year 1920, whether those founders, did they thought that they will get the protection in the year 1950? They never had such a thought process in their mind. So therefore, you cannot classify that 30 will be given, protection will be given only to the institution which was established post-constitution and not to the institution which was created pre-constitution. That classification is not required. It is not essential at all. So therefore, we cannot classify like that. Article 30 will, the protection will be given even to the institution which was established prior to the commencement of the constitution. So by applying these principles, by narrating all these principles, ultimately they have said whether AMU is a Muslim university or not, that test will be determined by the regular bench, by taking the guidelines, by taking the principles that we have enumerated in the majority view. Therefore, now it will be decided by regular bench whether AMU, ALIGARH Muslim University, is a minority institution or not. So they need to establish before the regular bench that the idea, the birth of the AMU has taken place from the minority community, purpose for the benefit of the minority community, and implemented by the minority community by showing documents, proof. Everything has to be done to convince that it is a minority institution or not. Now, my final question is why this was added in the landmark judgment. Very important, dear friends. What is the difference between a leading case and a normal case? Leading case means the name itself denotes that it leads and it becomes the law laid down by the Supreme Court. In this, leading cases become a guiding light for the similar cases. Here, the lordships have interpreted Article 30, Clause 1. How to see the establishment? We can see only the establishment in the Constitution. Where this IPI, idea, purpose, implementation, where does it come from? It comes from the rich experience, wisdom of the honorable judges. The constitution provisions remain same, but how it is being interpreted by the judges, that is important. Therefore, the Supreme Court is a final arbiter with respect to the interpretation of the constitution is concerned. That is how the evolution of law is. How right to go abroad is implicit in Article 21. How right to privacy has become a fundamental right in Article 21. Right to fair investigation, right to fair trial, right to speedy disposal, right to sleep, right to water, right to clean environment. It is all because of majesty of our judges. And we should never forget even the effective assistance by the lawyer like us. A good judgment is written by the good assistance. So therefore, if the Honorable Supreme Court is laying down a law, we are like the foundation. We have to make a research. If want to make a apple juice, a good juice will come from good apple only. So therefore, we have to give proper assistance to the honorable judges whenever it is required, dear friends. Thank you so much for your patience hearing. Read carefully and make notes, and I wish you all the best. Thank you so much. Please join us for a group photo, dear friends.